Misrepresentation in commercial contracts occurs where one party makes a false statement that induces another party to enter into an agreement, and these claims can have serious legal and financial consequences in Australian business transactions. A misrepresentation is generally a false statement of existing fact made before the contract is formed, which is relied upon by the other party when deciding whether to enter into the agreement. The statement does not need to be written. It can be verbal, implied through conduct, or arise from incomplete or misleading disclosures, depending on the circumstances. In commercial transactions, misrepresentation commonly arises during negotiations involving businesses, property transactions, supply agreements, shareholder agreements, and commercial leases. Examples may include inaccurate financial information, overstated business performance, misleading statements about assets or liabilities, or representations about future contracts, approvals, or commercial opportunities that are just not true. Australian law recognises several different types of misrepresentation. Fraudulent misrepresentation involves knowingly false statements or reckless disregard for the truth. Negligent misrepresentation can arise where a party carelessly makes inaccurate statements in circumstances where they owe a duty of care. There's also innocent misrepresentation, where a statement is false but made without fraud or negligence. Importantly, not every inaccurate statement will amount to actionable misrepresentation. Courts will often examine whether the statement was merely an opinion, sales talk, or prediction about the future, as opposed to a statement of present fact. The courts will also consider whether the other party actually relied on the representation when entering into the contract. If misrepresentation is established, the available remedies can be significant. A court may allow the contract to be rescinded, meaning it is effectively unwound and the parties are restored to their original positions as far as possible. In some cases, damages may also be awarded to compensate for losses caused by entering into the agreement. Misrepresentation claims can be particularly complex where contracts contain entire agreement clauses, disclaimer provisions, or non-reliance clauses, which are often drafted to limit liability for pre-contractual statements. However, these clauses do not always prevent a claim, especially where misleading or deceptive conduct under the Australian consumer law is involved. Because commercial misrepresentation often involves detailed negotiations, conflicting evidence, and significant financial consequences, understanding whether a representation is legally actionable and what remedies may be available requires careful legal and strategic analysis. Contact us today for a free 30-minute consultation with one of our experienced team of commercial litigation professionals and let us help you protect your rights.